It was very clear from the beginning that this case was nothing more than a extortion related, trying or designed to get Bragg to pay money. Good morning, Your Honor. Steven Caloiaro on behalf of the defendant, Bragg Gaming.
Good morning, Your Honor. Rory Kay on behalf of third-party defendant Spin Games LLC, Kent Young and Kamal Mishra.
Good morning, Your Honor. Danielle Barraza, 13822 on behalf of Brian Marcus.
Good morning, Your Honor. Todd Prall on behalf of the third party plaintiff.
Okay, these items, there are several items on calendar today regarding attorney's fees and costs. So I'll be hearing argument and I'll be taking this under advisement. It's been well briefed and everything, so you can go ahead and proceed with your motions and just emphasize, again, it's been well briefed on both sides, so emphasize the things you want me to pay particular attention to, so to speak.
Yeah, understood, Your Honor.
The first item on calendar is Bragg Party's motion for attorney's fees and costs.
Your Honor, me and Mr. Kay discussed, and because some of our issues are similar, Mr. Kay was going to lead us off, if that's all right with the court, with the spin parties.
Okay, that's Spin Games motion for attorney's fees and costs, right?
Yes, Your Honor, just because of the fact that Spin and Bragg both filed the offer of judgment. So, and then I'll talk about the NRS 18 afterwards.
Okay.
Thank you, Your Honor.
Thank you, Your Honor. Rory Kay for the Spin parties. I will be brief, and part of the reason why we've separated it out is my client only moves for their fees and costs. Excuse me, their fees under NRCP 68, and we filed a memorandum of costs under the cost statute. I will leave the prevailing party analysis to Mr. Caloiaro and Ms. Barraza, who moved for fees under the statute, requiring prevailing party status. Under Rule 38 or 68, I don't have to prove to you that my party failed. There's nowhere, there's that language in the rule. All I have to show is that my clients made an offer to the spin parties, or excuse me, to the full color parties, and that the full color parties failed to obtain a more favorable judgment. It's fairly straightforward in this case. We made an offer for $75,000 about 2 years into the case. We made another offer about 3 or so months before the 5-year deadline ran for $250,000. The full color parties rejected both of those, and so they haven't beat the offer of judgment. I don't think there's any real debate in the opposition about that. I will only point out, and Your Honor lived this as much as we did the last, I think it was 7 years, considering the COVID tolling. You know, my clients came into this deal under a game development agreement with full color parties. They were paid $75,000 under that deal. They performed substantial development work, and then this lawsuit pops up between the full color investors and Mr. Mahon and some of the full color entities. At that point in time, my client kind of threw their hands up. A year and a half later, they're somehow dragged into this lawsuit. We didn't believe there were meritorious claims, but we didn't serve an offer of judgment right away before discovery. We gave the full color parties 2 years to do any discovery they wanted. And then at about the 2-year reunion, when I will say a lot of the nonsense started, we offered to give them the money back. That was essentially the basis of our first offer of judgment. We offered them $100,000, which was, here, take your money back that you paid us and we'll go our separate way. They rejected that. 2 some odd years later, again, right on the eve of the 5-year deadline, Honor knows we hadn't conducted any discovery at that point in time. We said, fine, we've had enough. We'll give you $250,000. We made that offer jointly with the Bragg parties. Again, it was almost quadruple what the full color parties had paid my client under this game development agreement. Would have more than made them whole. They still rejected it. And so under Rule 68, Your Honor, they have to live with the consequences of that choice. I get it. It's a, you know, Rule 68 offers are always difficult, but I don't think the rejection of the offer was in good faith. We gave them multiple opportunities to get out of the case, as in my clients, with more money than they had paid my clients, both times, mind you, and they rejected it. Of course, Your Honor knows all of the things that went on with the 5-year rule, the lack of discovery that the full color parties had done in the case until a handful of months before the 5-year rule. This was always going the way it went. We still gave them the last offer of judgment to try and put an end to this. My clients have spent substantial money, as you can see from the fees, in all of the stuff that has occurred during that time.
Of course, dismissal was without prejudice, and another action was filed, right? That's now in a.
That's true, but that doesn't impact the Rule 68 analysis,
okay,
right? It's just, did they recover a more favorable judgment than the offer of judgment? and they did not. It's straightforward. They don't get to rely on the second action, at least with respect to the Rule 68 analysis. They haven't cited you any case where a court has looked at the pendency of a second action in evaluating Rule 68. So they really are asking you for unprecedented relief and rejecting our offer of judgment. I also think it's frankly, it's just not appropriate given some of the things that happened in this case that are very unusual. We put in Exhibit 1 to our motion a text message way back in February of 2020 from Mr. Mahon. He is the sole principal of the full color parties. He made it very clear what his goal was. It was war. It was to take the Bragg party stock to zero and to impose pain. And that is not a proper purpose for litigation, but not coincidentally, we made that offer of judgment shortly after he sent that text message out because we knew where this case was going. It wasn't going to be about the merits of the case. It was going to be, as he said, taking this to war and imposing unnecessary fees and costs on my clients. And so we tried to make the offers of judgment. He rejected them, and so he's got to be accountable for the same, Your Honor. With that, I'll turn it over to Mr. Caloiaro and Ms. Barraza with respect to the Chapter 18 analysis.
Morning, Your Honor. Steven Caloiaro on behalf of the Bragg parties. Mr. Kay's talked quite a bit about the offer of judgment. I'm happy to answer any additional questions you might have on that. The only thing that I'll kind of further note with respect to that issue is with respect to the Bragg parties, there was never a single instance or occasion wherein they explained how or why Bragg was liable for any damages. Their theory as to why Bragg was in the case changed and was based on this argument that they deserved an opportunity to acquire another company. Neither party had a relationship, but there was never, you know, like Mr. Kay, where there was a clear $75,000 dispute, right? So there was never even a number. Nevertheless, we came forward with the offer of judgment. And I think for us, what's really important here is the timing of that offer, Your Honor. The offer was handled right around when we were dealing with their motions to bifurcate, and specifically you denied their motion to bifurcate, and the writing was on the wall that this case was going to be dismissed, and yet they still had, I think it was 6 or 7 days in which to accept the offer of judgment. So they had, on one hand, you can take $250K, or on the other hand, this case is going to be dismissed. And they made what I consider to be very unreasonable decision to go forward with the dismissal and seek to fight about it. I think that demonstrates that their decline of the offer was unreasonable, given the posturing of the case. They knew already that you had denied the motion to bifurcate. Happy to answer any more questions on that, Your Honor, but given that they've never been able to offer even a single calculation, a single dollar figure, the offer from Bragg and jointly was spent for $250,000 more than reasonable. Their decline after you declined their motion to bifurcate was completely unreasonable, and I think for the basis for that reason under NRS 68 or NRCP 68, we should be given fees. With respect to 18010, Mr. Mahon said no one is getting out of this case absent a private settlement, and he made this threat repeatedly over the course of 5 years. When Bragg was involved in this case, it was very clear from the beginning that this case was nothing more than a extortion trying or designed to get Bragg to pay money. I've come before you time and time again over the last 4 years saying I want to get to the merits of this action because there are none, right? And once we get to the merits of the action, it's going to be plain that there's no legal cause of action. We never got there because Mr. Mahon was more concerned with playing games, trying to inflict pain, and trying to force Bragg into a settlement than he ever was about litigating his case. I'll bring you through some of these things that we've dealt with, and it starts out, Your Honor, with the fake subpoena. As you will remember, he reached out to the DOJ in an unrelated action, saying, oh, by the way, I have information regarding parties that may be involved. They say, great, give it to us. And he said, oh, I'm not going to give it to you without a subpoena. So then he authored the subpoena, which they eventually issued, but then he filed it with this court to obtain a stay and then hid who issued the subpoena. Once you finally were able to let us review this in camera, we contacted the DOJ attorney and said, our client's really a part of this. And he said, no, it's only because this guy told us he needed a subpoena. And the day I contacted the attorney for the U.S. attorney in the Middle District of Florida, That same day, he told Mr. Mahon his services were no longer needed because he realized he was using the DOJ subpoena to obtain a tactical advantage. Again, that whole sham that he perpetrated on this court was designed to inflict pain on Bragg so they would settle the action because of this supposed criminal situation. When that failed, he then sought to file a preliminary injunction to prevent Bragg and Spin from joining. He did this 6 months after the merger or the acquisition was announced. Again, that wasn't because there was any sort of real threat or harm. It was because of the fact that he thought, if I can stop the transaction and cause them enough pain, they'll settle the case out. That didn't work. So what did he do after that? He then started emailing and sending threat letters to various stock appraisers, lying to them about your preliminary injunction, threatening regulators with lawsuits if they approve the transaction. Why? Because he was trying to stop it and figured if I inflict enough pain on Bragg and Spin, they'll settle the case. You then issued a gag order. The court in Caprihana has recognized that the legislature can award attorneys, or the court can award attorneys fees in all appropriate situations to punish for or deter frivolous or vexatious claims and defenses. And a claim is frivolous or groundless if there's no credible evidence to support it. Similar to Capiana, Your Honor, third-party plaintiffs did not present any evidence of claims. They didn't present any evidence of claims about how Bragg did something untoward. Bragg was part of this grand conspiracy. And not only that, they admitted during discovery that some of the claims they had no basis for. They brought a breach of contract against Bragg, but admitted in a request for admission, we don't have a contract with Bragg. They brought breach of good faith and fair dealing. They admitted that there was no contractual relationship which would give rise to those claims. They admitted to us that we brought these claims with you and have no basis to defend them. So for all these reasons, Your Honor, it's clear that this case isn't about litigating the merits. It was about forcing Bragg and Spin into a settlement agreement. Fortunately for us and unfortunately for him, we prevailed. And now we're in a situation where the case has been dismissed and we're entitled to our fees and costs because we've had to defend this over the course of the last 4 years. With respect to the prevailing party issue, Your Honor, I think there's 2 points that I want to raise because I think that's going to be something that you're going to have to deal with given the dismissal without prejudice. The first point, Your Honor, is Nevada case law is pretty clear about a dismissal even without prejudice if there's a material alteration in the relationship of the parties. When we dealt with this in our brief, we explained to the court that all of the claims they've raised are time barred. And specifically in our cost motion, we didn't want to repeat it because it's long, because there's a number of claims. We outlined their cause of action against us, the basis for that, and the date that the statute of limitations ran. They never disputed that. So now under the EDC local rule, they have not disputed that that the statute of limitations have run, and the court should accept that as fact under EDC R 2.20. Setting aside the fact that all of their claims are time barred, and we'll handle that in the other case. Nevada case law also doesn't require dismissal with prejudice for the purposes of NRS 18010. And public policy is pretty clear on it, right? If you could continue to file frivolous and vexatious actions, but then dismiss before the court ruled on it without prejudice, then you would never have any sort of punishment. You could continue to behave in this sort of manner. And so the court is pretty clear. They've dealt with this issue directly in California. We cited that Mong Chong Loon case to you. And the court noted that even in that case where it was a dismissal without prejudice, and there was a potential for refiling the action, that it warranted fees under a similar provision because of the vexatious litigation. So with that, Your Honor, I'm happy to answer questions, but I think that this is a pretty extreme case of where there was no attempt over the almost 4 years that the Bragg parties were in, or 5, I guess now, to really seek merits on this. And again, I sat here time and time again saying, let us get to the merits, and they didn't want to get to the merits. So.
All right, thank you.
Thank you.
Response?
I assume I'll go ahead with this and we'll deal with the other motion from Marcus afterwards. Is that we must do?
Yes.
Okay. Your Honor, I just want to top all these issues. I want to start with the simple fact, Your Honor, that you made the decision. You had perfect power. You made the decision to dismiss this case without prejudice. under Rule 41E, the 5-year rule, you had the authority at that time to dismiss it with prejudice. In fact, the rule says it would be dismissed with prejudice unless the court determines it's appropriate to dismiss it without prejudice. They brought all of these arguments that they're bringing now about claim bad faith, all this stuff. Every single argument that they've raised today was raised there, seeking a motion with prejudice at that time. You made the determination it wasn't appropriate at that time to dismiss with prejudice, which you could have done. And nothing has changed. They're basically trying to get you to change the ruling you've already made, that this case was dismissed without prejudice, which means that there's no prevailing party. And it also means that there's no way to show that they have performed better than their offer of judgment. And in fact, if you look at their briefs, when they run out of legal arguments, they always revert back to that. Oh yeah, well, he did all this stuff. You already heard it all. You heard every single thing. And the record is full of what happened in this case. They've told their side, we've told our side multiple times. Their statements about the subpoena are not accurate. With the subpoena from the U.S. Attorney's Office, it was not authored by my client, it was authored by them. It's true he asked for one because they were asking for him to produce documents and he didn't want to produce them unless he felt protected that they had a basis to do it, especially when some of the documents are confidential. And so that whole thing, and you already heard all this. You heard it multiple times. You never sanctioned him for that. You could have. They asked for fees. You didn't grant them. So all this has been decided multiple times. And here there's nothing new for them to come on. But you made the determination to dismiss this case without prejudice. You determined that not only because another case has been filed, but also because of the complications and the issues that were plagued with this case that was nobody's fault. Bragg argued just now, oh, we wanted to get to the merits. We wanted to get to the merits. Look at the record, Your Honor. Bragg was avoiding the merits just as much as anyway. They filed every kind of motion to dismiss they could think of. They filed every kind of motion to dismiss they could think of for lack of jurisdiction. Some of them which you granted, some of them which you did not. The idea that they were trying to get to the merits while we weren't is really not what the record shows. That being said, Your Honor, let's just briefly address the issues of the prevailing party and the offer of judgment. There's no question that a dismissal without prejudice does not result in a prevailing party unless there's limited exceptions which don't apply here. And one of them that the cases refer to is if the court actually did make a ruling rebuffing the claims. The court did not do that here. The court dismissed on the 5-year rule, which made no findings whatsoever on the merits of the claims, period. They didn't make a finding on the statute of limitations. The court made no ruling on whether statute of limitations had been expired or not. And the fact is the statute of limitations is an affirmative defense, which can be waived, which other things affect. If a lawsuit were to be brought again, those issues would be for that court to deal with. This court can't really make decisions. In fact, they have not cited a single case where they do have cited cases that say, yeah, sometimes a case is dismissed without prejudice. It's a practical bar because the statutes have run. But none of those cases say that they are a prevailing party because of it, or that they're entitled to fees and costs because of it. In fact, they didn't come up in most of those cases. In fact, one case, the Kip case from Nevada, actually says that even though a dismissal without prejudice could result in a practical matter being a dismissal that's barred by future claims because of statute of limitations, the Supreme Court still reviews a dismissal without prejudice with a lower standard than they would a dismissal with prejudice as a heightened standard. That means the Supreme Court views them differently. And so even if it potentially could be barred, a second action could be barred. That's really an issue for the next, if a case is brought again, the court there would have to address whether that statute of limitations has expired or not. If it's not asserted, it can be waived. There's multiple factors that are not here. So the statute of limitations argument is kind of a red herring. It's not an issue here. The court never made a determination on it. The court's never addressed the merits at all in any of its orders. And at this point, that dismissal without prejudice, the court can't now address the merits. Those are passed. So there's no prevailing party here, is the point.
Well, I think the contention is that Rule 68 doesn't use the term prevailing.
I will get to Rule 60. I was addressing the other arguments first. I apologize. Bragg brought a motion under NRS 18 based on a prevailing party. So I addressed that first with the statute of limitations. Rule 68, you're right, is a different analysis. And it does not say per se that you have to be a prevailing party. Obviously, someone can prevail and not beat the offer, and that means that they're not, that it's a different analysis. They have to do better than the analysis. The analysis here, though, Your Honor, is that they don't cite any law that suggests that a dismissal without prejudice would trigger, in Nevada, would trigger the offer of judgment. If a dismissal is without prejudice, that means that the claims are still valid and they could be brought again. In fact, here, some of the claims have already been brought again. Now, before I get to the other analysis, just imagine if you would say, okay, you're right, Bragg, you're right, Spin, you've met your burden on the offer of judgment, therefore I'm going to award fees and costs. What if Full Color Games prevails against these parties in the next action and recovers more with the same claims that were part of their offer of judgment? Mind you, they didn't make an offer of judgment that split up the claims. They offered a judgment all the claims. And we were to prevail, that would be unjust to my client to have paid their fees when they ultimately prevailed and recovered more than the offer of judgment. So dismissal without prejudice under those circumstances, Your Honor, is not what that rule is for. Second of all, we have cited many authorities from Florida, Michigan, and other places that go right on point with these things. Those courts, even though their statute or rule that creates an offer of judgment situation, which we acknowledge, Your Honor, the Florida statutes, the California statutes, all of them are slightly different. They're not, none of them are exactly the same, but they have substantive things that are the same. And the Florida courts, like our statute, doesn't mention with or without prejudice in the rules, but those courts have all determined that under those situations, if there's a dismissal without prejudice, it doesn't trigger the offer of judgment statute. And we contend that those rules are more appropriately applied in this situation, the Florida and the Michigan cases, which are all briefed in our case. The one case that they cite that was not originally raised by them, but was brought up in their reply, is the Mong Chong case. I'm probably saying it wrong, I apologize. The Mon Chong Loon Trading Court case out of California. And that case cannot really be applied here. And here's why. Number one, it was a voluntary dismissal without prejudice. And number two, the California rules for voluntary dismissal are different than in Nevada. Nevada allows you to dismiss a case without prejudice only if no one has answered or filed a motion for summary judgment. Otherwise, you have to file a motion to dismiss without prejudice, and the court has to approve it and then can only grant it on terms and conditions it deems proper. In California, the rule, which is cited in the Mong Chong case, states that a party can basically request a dismissal without prejudice at any time before trial and can have it granted as long as it pays all the costs. Again, that's different than Nevada, because Nevada, you're only required to pay the filing fees if you do a voluntary dismissal before there's an answer. And even if the court grants it later, it's only the filing fees, it's not all the costs. And so the Mong Chong court determined that because that statute says that a voluntary dismissal without prejudice requires you to pay all the costs, you're a prevailing party, and that's a judgment that you could get more of your fees under an offer of judgment. The Rule 41 in Nevada and Rule 68 don't have the same, just don't work the same as they do in California. And so that ruling is really not applicable here. They cite a lot of cases that they say, oh, we always look to California law. We always look to California law. We do look to California law. That is true. But the cases they cite that look to California on the offer of judgment issues, none of them say we're looking to California to determine whether there's a more favorable judgment. They're all about different issues that aren't at issue in this case. So the point is that case is different. And we believe that the cases that are more applicable here are the Florida and Michigan cases that basically hold that a dismissal without prejudice does not trigger the statute, especially when there are claims that can still be brought. And again, the Florida rule and the Nevada rule doesn't say that specifically in the rule, But the courts in Florida have determined that that's the case, and we believe that they are persuasive and should be followed by the court here.
When you say it does not trigger the statute, you're referring to the statute or the rule?
I'm sorry. Well, there's both a statute and a rule, right? NRS 117 and NRCP 68. They don't trigger the rule if there's a dismissal without prejudice. And it's
Well, the
important.
statute is the 18.010.
Well, I'm talking about the offer of judgment statute.
Okay, very
I
good.
apologize.
All right.
NRS 1810 has to have a prevailing party. And that's where our argument is there's not a prevailing party. Does that make sense?
Okay,
Offer of judgment has to show that they beat their judgment. We're arguing they can't show that if there's a dismissal without prejudice, and there are other cases and other jurisdictions that agree with that position, specifically Florida and Michigan. Frankly, California, they haven't cited any cases that directly address the issue here. The Mong Chong case, as I said, is a very different case with applying the different rules, and they haven't really cited any authority that directly apply here. With that being said, Your Honor, I think those are the primary points that I wanted to raise. Obviously, there's lots of other issues in the brief that are smaller, but these are the main issues here. Whether or not they're even entitled to fees at all, whether or not they're entitled to their costs at this point. And I would just point out again, their offers of judgment were for the whole case, all claims. They didn't try to say, oh, we're only doing it on these claims. They wanted all the claims included. Some of those claims are actually still being litigated actively, and the other claims were only dismissed without prejudice. The court never addressed the merits of a single claim in any ruling. And when they dismissed under 41E, the court doesn't have jurisdiction to look at the merits anymore. And that's what they're asking the court to do, is still go back and look at the merits of the claims, which were never addressed. And with that, unless you have any other questions, Your Honor, that's what I have.
all right, thank you. Briefly, spin Bragg parties.
Thank you, Rory Kay, for the spin parties. I just want to point out a couple of things in response to Mr. Prall's argument. One, in our brief, we didn't cite a single California case. We only cited Nevada cases on Rule 68 because the result under the rule is very clear. And I want to make sure that we're all on the same page with respect to the language issue. The rule in subprovision F, subprovision 1 says if the offeree rejects an offer and fails to obtain a more favorable judgment. In other words, full color parties reject the offer and fail to obtain a more favorable judgment, they have to bear the responsibility under Rule 68. Now that failure in the language of the rule doesn't say that the failure has to come through trial, doesn't say that the failure has to come through summary judgment, doesn't say that the failure has to come through a dismissal of the merits. It is a failure for all purposes. Of course, that's because all Rule 68 focuses on is the action in which the offer was made. We know that because we quoted the Dillard Department Stores case to you, Your Honor, in which the Nevada Supreme Court said that the purpose of Rule 68 is to save time and money for the court system, the parties and the taxpayers by rewarding a party who makes a reasonable offer and punishing the party who refuses to accept such an offer. Now, how would that policy purpose be effectuated if, as Mr. Prall argues, an offeree could reject an offer in a first case and refile the claims in duplicative fashion in a second lawsuit? That doesn't save anybody time and money. Certainly doesn't save the court system, because now Your Honor has dealt with these claims at taxpayer expense for 7 years. Now another department apparently is going to be dealing with these claims for who knows how long there. That's why we made the offer.
Okay. All right, thank you.
Very quickly, Mr. Prall talked a lot. At no point did he ever dispute that his claims are barred by the statute of limitations. Even now, he offers no evidence that they're not under, with respect to NRS 18010 and whether there's been a material alteration for the parties. He has no defense for his and his client's behavior during the course of this litigation. With respect to NRCP 68, Mr. Prall said, well, if in the next action my client obtains a better judgment, then it's going to be unfair. That's a separate action. We can offer an offer of judgment in that action. And guess what? If he beats that offer of judgment in that action, he won't have to pay our fees. And if he loses it, then I'll have to pay our fees in that action. But simply being able, as Mr. Kay mentioned, to continually refile after you deny an offer of judgment completely takes out the purposes and intents of NRCP 68. The only analysis this court needs to do is whether or not in this case, did Mr. Prall receive and his client receive more than $250,000. And if that answer is no, then he was not successful, and we're both myself and Mr. Kay's clients are entitled to their fees under NRCP 16.
All right, thank you very much. And the last motion is the third party defendant Brian Marcus motion for attorney's fees, costs, and interest.
Good morning, Your Honor. Danielle Barraza on behalf of Mr. Marcus. I'll also be brief. To remind the court briefly of the background, Mr. Marcus was also dragged in unwittingly into this litigation. He was never an original plaintiff. His only involvement was signing a truthful declaration in the underlying matter, which upset the full color game parties. They sued Mr. Marcus for racketeering, securities fraud, abuse of process, amongst other claims that were never heard on the merits because they failed to conduct discovery on the claims and allowed the 5-year rule to expire. Our motion is sought under NRS 18.010 as a sanction due to the frivolous and vexatious nature of the claims.
All right, now there's no offer of judgment on this.
Correct, Your Honor. This is strictly the Rule 18, NRS 18 analysis. And we've submitted the evidence. We've submitted the emails that were sent from Mr. Mahon to Mr. Marcus in the lead up to this litigation. The threats to hold Mr. Marcus up in litigation for years to come, promising him he'll have to spend millions of dollars in legal fees to fight this, saying he will spend the next 10 to 12 years of his life in court fighting the claims. Those are attached as exhibits C, D, and E to the motion. We've attached the email that was sent to the other partners in Mr. Marcus's law firm, claiming he had been charged with racketeering. It was clearly designed to hurt Mr. Marcus. That's exhibit F to the motion. I think counsel for the Bragg parties hit the nail on the head when he commented this was a very transparent extortion job that went on, which extended to Mr. Marcus. And it gets to the point of the harassing nature of this litigation. As far as the Brunzell analysis that was provided, there was no dispute as to any of the specific entries. Mr. Marcus has consistently sought dismissal of this case, and that's what was awarded by the court. He was a prevailing party. And again, as was previously stated, there was no requirement of a dismissal with prejudice for him to be deemed a prevailing party. We've seen the argument in the opposition that Mr. Marcus was not the one who filed the underlying motion to dismiss on the 5-year rule grounds. But that being said, he wasn't required to file that motion. It does nothing to change the prevailing party analysis, does nothing to change the Brunzell analysis. Ultimately, the relief he wanted, which was dismissal of the claims against him, was granted, regardless of the method the court chose to achieve that. And then we've also addressed that this court obviously has jurisdiction to review this matter. It's a collateral matter, which there's plenty of case law on that the motion for fees can and should be heard on its merits. And I'll answer any questions if there are any questions.
Okay, thank you. Yes.
Your Honor, I'll be brief here. I think we've already covered some of these same issues already. Again, Your Honor, your dismissal of this case was without prejudice as to all parties. When they brought their motion for summary judgment and we told the court we thought that either they were dismissed under 41E like everyone else, or then we moved to amend to clarify whether the court was dismissing all the parties, or whether or not we made some other analysis that says maybe none of them should be dismissed. You rejected those arguments, but you had all the information again, and you determined that all the claims should be dismissed without prejudice. And without prejudice does not create a prevailing party. They haven't pointed to any law, especially for the purposes of fees and costs in a case. Just to make clear, Your Honor, we did bring a counter motion to retax costs. It's intertwined with this, and there's no reason to re-argue that. I think it's part of what we're doing here. So just to make it clear, there is that motion, but that motion is primarily based on the idea that they're not a prevailing party. And so they can't get costs, they cannot get fees. And again, they have not pointed to any case where this has happened. They pointed to cases that say, oh yeah, you still have jurisdiction to hear fees arguments. That's true, but you still have to have a basis for those fees. And the basis for the fees, the only one they have here is that they're a prevailing party. A dismissal without prejudice does not create a prevailing party. The only cases where it has is where the court actually does in some way address the merits. Sometimes on a motion to dismiss, a court will dismiss without prejudice, but the court will find that they haven't stated a claim and they actually address the claims. The court did not do that at all in this case. The court already decided, could have dismissed it with prejudice, could have triggered a prevailing party, determined that it was not appropriate to do so.
So your contention is that the prevailing party concept does apply to NRS 18?
It's clear in the language. It says it only awarded to a prevailing party. NRS 18 says awarded to a prevailing party. And it has to be prevailing. And we're saying that they don't even meet that standard. And just briefly, Your Honor, there's a high bar to under NRS 18 1T2B to show the case that the claims were frivolous and brought without merit and all the things they have to prove. They haven't done that here. In fact, the court never addressed the merits in this case. The court has never made any ruling that there wasn't enough evidence. The court's never addressed the merits at all. And a court can't now, after it's dismissed the case, determine, oh, I'm going to go and look at the merits of the case to determine whether it was vexatious. That's not the way it works. If it dismissed with prejudice, we'd be in a different boat. The court did not dismiss with prejudice, dismissed without prejudice. And I really don't, I mean, everything else is briefed. I know you're going to take another advisement and look at everything. Those are the points I'd like to make. Again, it comes down to that. There's not a prevailing party if it wasn't dismissed without prejudice. The statute of limitation arguments were never addressed by the court. They're still live issues for another court to determine if another claim is brought.
Okay, thank you.
Thank you.
Last word. Ms. Barraza?
Oh, thank you, Your Honor. And I did just want to briefly address as well, as far as the claim that these are still alive claims, there has never been a separate action filed against Mr. Marcus specifically. So I understand there is that separate action as far as other parties, but there is no separate action that was attempted to be filed against Mr. Marcus. And I think that's the only thing I specifically wanted to address on that issue.
All right, thank you. These items stand submitted. I'll review them further and issue my rulings. Okay.
Much, Your Honor.
Thank-